All right, good afternoon, folks. My name is James J. Bakhtiari. I'm the Consumer Advocacy Campaign Coordinator at the Virginia Poverty Law Center. And if you are looking for hot topics in civil litigation for legal aid lawyers, you came to the right place today. This afternoon, we have Christy Kelly and Andrew Guzzo. They'll be giving the presentations today. And if you have any questions, and I'm sure many of you will, please be sure to write them in Whova. So go to Whova. I'm writing the questions there. And at the end of the presentation, we'll get to questions for either Christy or Andrew. So please direct them once they come up. And without further ado, I'll go ahead and hand the ball over to you, Christy, if you want to introduce yourself briefly, and we can go ahead and get started.
Hi, everyone. I'm Christy Kelly. I am a consumer lawyer in Fairfax, Virginia. I practice in federal and state courts, Maryland, DC, and Virginia. I'm a former legal aider. So of all these speaking engagements that I do, this is perhaps the biggest honor to come and speak to you guys about how we can help legal aid clients. And so if ever you need anything or have any questions, I am here, and so is my partner, Andrew Guzzo, who I will let introduce himself.
Hi, everybody. I'm Andrew. I'm Christy's partner. I've been practicing law for 10 years now, and it's been exclusively in consumer protection. Like Christy said, we're here to help anyone and everyone with anything they need. I am actually coming to you live from Hawaii, where I spend most of my time on that contingent of the firm. But Virginia is still near and dear to my heart. And so I end up practicing mostly Virginia law.
And so today we're going to be talking about hot topics in civil litigation. And everyone has the Whova app and so I am new to Whova, but I looked at the questions that had been answered or asked so far. And so Andrew and I thought it was best to kind of have more of a dialogue type conversation for our presentation. And I want to start by kind of addressing just some tips on litigating in both state and federal court that Andrew and I have found have really been effective in advancing our litigation and maximizing the recovery for our clients. And so I want to start by just addressing what I consider to be the most important thing when you litigate in either state or federal court, and that is discovery. So many lawyers think discovery is beneath them. It is a paralegal or legal assistant job. And I couldn't disagree more. I think discovery is how you build leverages in your case and win cases. And that is where I think you are a good lawyer if you do discovery and know how to do discovery to maximize the leverages for your client. One of the questions we had in advance of our session was how to keep a case moving in state court. Well, in state court, unlike federal court, you are under Virginia Supreme Court Rule 4, you are allowed to serve discovery requests with your complaint. And so I believe if you serve it with your complaint, they have 28 days to respond when they're served. So they have a little bit more time, but you automatically start your case from a position of building leverages and power by serving your discovery request with your complaint. And so they have to pay attention to your case. They have to respond to discovery. Once you get discovery responses, you can meet and confer. You would be able to file a motion to compel if you have deficient responses, but it keeps the defendant engaged on your case, and whoever is working the case from the company or corporate representative angle, they have to pay attention to your case because they're requiring the company to do work in terms of discovery or responding to your case. And so, in my opinion, the best way to keep a case moving in state court is to serve discovery early and work your discovery. If there's deficient responses, schedule a meet and confer, file a motion to compel. If you identify third parties, you can issue subpoenas. And then if that doesn't work, you can go ahead and serve deposition notices and start taking depositions in your case. And that will definitely help you build leverages and push your case forward. And if you're trying to get a resolution, by doing those things, you will get a much quicker resolution in state court, in my experience. In federal court, on the other hand, you have to wait to have a 26F, or depending what court you're in, a scheduling order has to issue. Either have a scheduling order or a 26F. And a lot of times defendants will try to avoid having a 26F until a scheduling order has been issued, and because they don't want to start the discovery process, because they want to avoid doing discovery and the work that it entails. And so I find in federal court the same thing. As soon as I'm able to, I try to have my 26F or issue my discovery, because it starts prioritizing your case for whatever defendants you have and letting them know you're serious and it's a priority for you. And I find that I'm able to build my clients' leverages and negotiate fair and fast settlements for my clients that way. Andrew, I don't know if you want to talk about some general tips that you have now.
So just one general thought, and I'd be interested to hear what older lawyers have to say than me, but I feel like civil litigation has become more adversarial as the world has become a little bit more adversarial. And in that sense, I feel like maybe it's just because of the players that we sue, or the world we live in, that there has been less honesty in pleadings and filings than I've seen in the past. And I think that creates problems, a variety of different problems for us. Whatever we do, we should never sink to that level. That's the most important thing. Is I think you combat that with citations, attachments, pleadings that prove what you need to prove. No longer do we necessarily take it for granted that the court will just believe what we necessarily say, because it is so vehemently opposed by the other side that I find us attaching more things just to cite basic facts. And you just can't take for granted, I think, that the other side is going to be honest. To give you one example, Christy and I were recently involved in a case where there was a declaration filed. It was probably 8 pages. This same declaration was then represented to the Fourth Circuit that it was honest and it was all the facts in the case. And it turned out to be objectively inaccurate, to the point where one judge in our case wrote a 45-page memorandum opinion outlining all of these various different misrepresentations. Now, that's an extreme example, but I feel like that conduct is more permeating everyday cases than at least have been in the past. So it really slows things down. I think it muddies the waters a little bit when the parties can't even agree on the basic facts and they're fighting about that. I think it's advantageous to the defendants, because nobody really wants to deal with a case like that. And I feel that those types of things have permeated into discovery. Like Christy said, that's a big focus of our firm and myself and Christy doing that work to push it, to get all of the information we need in that particular case, to get it as quickly as we possibly can, because the more and more it drags out, information goes bad, things like that. In my view, courts continue to do a really great job at sorting through this stuff, but it is there, and it has slowed down our litigation. But I think the only thing we can do to combat and fight that is to just do the best we can and to back up everything we say.
And just kind of tying off what Andrew said, it is your job to, be cordial and courteous, but you need to verify that what they're telling you is true. And that's why discovery is so important. And in the case Andrew discussed, we didn't learn how false the statements were until we did third-party discovery to confirm the facts that were at issue in that case. And so it's important to, be cordial and work together, but also to, verify information that is important to your case. And I know it's so hard to be saying this to legal aid lawyers, right, who have limited resources. And sometimes it's difficult to, even file affirmative cases due to the demands and the constraints. But if you ever need help or need resources or need someone to pay for service or, transcripts, just email Goose or I. We're here to help, and we're happy to do what we can to make your job easier. And so we're here as a resource, and, I'm not, trying to make your life more difficult by saying how important discovery is, but if you ever need help with anything, we're happy to help. But it is just, to me, it's the most important lesson I've learned as a litigator is the importance of doing a good job in discovery. And I think that has helped me to resolve my cases in very fair and efficient manners for my clients and get good outcomes. We're going to go over kind of the main consumer protection statutes that we use and see, and kind of the emerging issues that we have identified in our practice that we think would be pertinent for legal aid practitioners as well. So you can be on the lookout for some hot topics in civil litigation. And I'm going to turn it over to Andrew right now to discuss maybe our favorite statute, the Fair Credit Reporting Act.
So as many of you probably know, there's a federal statute called the Fair Credit Reporting Act. That statute governs consumer reporting agencies, those that furnish information on consumers, furnishers of information, those that furnish the information to the consumer reporting agencies, and users of credit reports, employers, companies who, property management companies, things like that. Couple things that have been new and percolating in the FCRA land. Courts have given traction to, not necessarily in Virginia federal courts, but across the country, there is a new defense being pushed by credit reporting agencies that deals with factual versus legal inaccuracies. And the credit reporting agencies often look to less experienced practitioners in these cases to push these cases against people who haven't filed, dozens of FCRA cases, and try to get someone with less experience with the issues to make good case law in favor of the credit reporting agencies. And the basic issue is they say consumer reporting agencies are not responsible where the inaccuracy in the report stems from a legal dispute as opposed to a factual inaccuracy. So a few examples of that, including ones that Christy and I have encountered. One of the big areas you'll see this is in a situation where state law or some other law renders a debt void. So in Virginia, Chrissy and I have had experience with this in a Heath case that was pending in the federal court in Richmond, where we sued on behalf of 4 of our clients after a major class action settlement involving cash call, which canceled their loans, which were void to begin with. And TransUnion took the position in that case that there was no inaccuracy in the report, which is an element of pretty much every claim under the FCRA, because it was a legal dispute between our client and this particular debt collector who had purchased the debt before our settlement with cash call. We ended up winning that motion before Judge Gibney. He didn't publish an opinion in that case. It ultimately ended up in a class settlement. But courts have in other situations come to different conclusions. And what they say is that consumer reporting agency isn't in a position to adjudicate that type of dispute between a consumer and the credit reporting agency or the debt collector. As a matter of statutory interpretation, we fought really hard that that's just wrong for a variety of reasons, that the FCRA doesn't say factual versus legal inaccuracy. It uses the word inaccuracy over and over and again. That cannot arise by operation of law or by operation of fact, but it doesn't make a difference. The FCRA also has a default that says, more or less, if a credit reporting agency doesn't know, it shouldn't report something. And so for a variety of different reasons, we fought really hard and we were successful in that case. You might see it in other situations of reporting an eviction that was unlawful where the consumer is still fighting it. But it's really become one of the primary defenses in a Fair Credit Reporting Act case that they're pushing to the outer limits. And I think that you perhaps could see something like that if you file a Fair Credit Reporting case. Similar to the legal versus factual inaccuracy, there's also a collateral estoppel defense that the CRAs are pushing. When I say CRAs, I mean consumer reporting agencies. And that defense involves cases where furnishers are not parties to the litigation. And so a consumer sues the credit reporting agency to litigate the accuracy of their underlying debt, as opposed to suing the furnisher for whatever reason. And courts have been hesitant to really weigh in sometimes on those disputes because in certain situations, court decisions could be binding on the furnisher as a key stakeholder, even though they're not a litigant to that particular dispute. And so it's just another thing to be mindful of if you're considering filing an FCRA case, is that if you're not adding the furnisher, will I deal with one of these collateral consequence, collateral attack arguments? Few other hot topics. We're seeing more and more problems with tenant screening reports. We have it. I think it's probably because it's becoming more and more prevalent as the nature of this information becomes cheaper to access for property management companies, employers. Right now, I think you could probably go to some of the bigger tenant screening consumer reporting agencies and get a report for pretty cheap. Because they're cheap and they're streamlined, there is often many inaccuracies in these reports. Christy and I have done a lot of these cases, and it's shocking how bad the algorithm is that they use to match the information in these cases. Oftentimes they will match based on just name alone, not even date of birth. And oftentimes they won't match based on social security number, a lot of times because the records aren't available, at least the full social in court. So the CRAs are not investing a ton of resources in these reports, and they often lead to inaccuracies. To give you one example, Christy and I recently filed a case against a company named RP Onsite. They had matched our client, Terry Brown, to a sex offender record from DC, even though the name on the record did not match the name, his date of, or the date of birth on the application did not match the date of birth of the record. He was labeled as a sex offender who was guilty of a felony for attempted first-degree sexual abuse. It cost him his ability to rent a property, even though he was born in a different month and a different year, and the record clearly said that. We filed it as a class case. It has recently been resolved, and the class data showed that there was more than 1,400 people in this particular class who had not the same date of birth as the sex offender on their application, but nonetheless were attributed to these records. Other examples that we've had on these reports being accurate is, or inaccurate, is labeling traffic offenses as criminal offenses, which they're not in Virginia. Truncating and suppressing certain information that they receive to make the information appear a lot worse than it is. For example, there is one consumer reporting agency who obtains bankruptcy data but doesn't report a consumer's discharge. And so it makes it seem as if the consumer still owes a balance on those particular accounts. We are seeing many of these same issues in employment background checks. Usually the companies who obtain this, furnish these type of specialty reports, i.e. not Experian, Equifax, and TransUnion, they also furnish reports to employers for employment purposes. And so you see a lot of the prevalent errors that you would see in tenant screening reports in employment reports. Christy, I don't know if you have anything you want to add to that.
Yeah, just a couple things. I mean, sometimes it's hard as a legal aid lawyer to identify Fair Credit Reporting Act cases. I remember when I was at legal aid, the first time I actually identified a case was when I had this 19-year-old girl come into my office and tell me she wanted to file bankruptcy because her mom's debts were reporting on her credit, and it was preventing her from getting credit and also obtaining employment because she was appearing, in a background check as not credit worthy. And so that was my first real, experience with the Fair Credit Reporting Act, because in fact, she didn't need to file bankruptcy because they weren't her debts. And she was just being mixed up with someone her mother, who had a similar name. And so we were able to help her and get her financial compensation for her trouble. But it is just a huge problem. Legal aid clients are trying to access credit, employment, housing, and they need their consumer reports to be accurate. And so when they're falsely called a sex offender because they have a common name, that's a problem. If, they had a bunch of traffic stops because they were African American and they were profiled, and now those are being reported well after the 7 years and making someone appear like they have all these criminal records when in fact they were traffic infractions and they shouldn't be reported. That's a problem too. The other, issue that we're seeing a lot of, and it's really unfortunate, is that a lot of these tenant screening companies just report eviction actions and they don't report the outcome. So if a tenant, they just report a filing and they don't report whether the tenant prevailed or it was dismissed or vacated, etc. Hopefully with the expungement bill that was passed, when a tenant prevails or an eviction action is resolved in their favor, they can get that record expunged, so it won't be reporting at all, because some landlords don't even care whether a tenant was sued by some landlord just being a jerk and prevailed. They just care that there was a filing. And so if we can get those expunged, that's going to be a really important thing to do to enable people to access housing in an affordable manner. The other thing we're seeing a lot of too is people falsely being labeled as deceased. And those are really great cases because, if they're in your office, they're not dead. So they would be able to recover monetary damages for that. The next hot topic and way to build leverage is using the Real Estate Settlement Procedures Act. That's typically in a mortgage servicing context because it applies to mortgage servicers. There are a lot of regs that were implemented, and I know I've done a presentation or two before for legal aid on RESPA and the new Regulation X when it was new with Dodd-Frank, but it's still a really powerful statute because under RESPA, you can build leverages by exploiting the incompetence of mortgage servicers. And so if your client has some sort of error or is trying to obtain loss mitigation, it must write to the designated address on the back of the mortgage statement for qualified written requests. If it doesn't go to the designated address, it does not count. And it can address any error or issue. We have disputed, property inspection fees when our client was clearly living at the property because they were pursuing loss mitigation. We've disputed, denials of loss mitigation when our client submitted documentation in a timely fashion. We dispute, convenience pay fees when there's no basis for those fees. We dispute misapplication of escrow accounts when our client is disabled or a veteran. There shouldn't be an escrow account, and there's a lot of different things that you can dispute in your notice of error. We also always request information as part of our qualified written request, because the mortgage servicer will not provide the information. And so what we do is we'll ask for a copy of servicing notes. We'll ask for any recordings if there's a specific time frame where you're saying, oh, I paid this much because I talked to Jenny in mortgage servicing department X, and she told me to pay this much. And so please confirm that I paid what you told me to. Don't mark me as late. And if you're not going to do that, please provide me the recording of my telephone call with Jenny, on this date. If you're not going to waive any default related charges, please provide me the invoices for those charges. Or please provide me the letter you said you sent me, or whatever the case may be. And inevitably they don't provide it. And that in and of itself is a violation of RESPA, where your client can recover monetary damages. They get statutory damages plus actual damages. 2 notes on damages. There is not a lot of Fourth Circuit case law about actual damages that are permissible under RESPA. There's some bad pro se cases in Maryland that say, it's not like the FDCPA, I was stressed type damage, and that's good enough. But we had a good decision in front of Judge Ellis where he found that the unliquidated damages of stress and inconvenience, like I wasn't hungry that day, my husband and I got in a fight, that counts under RESPA. So that's can be really important to enhance the value of your claims. And if you're ever in a situation where you're briefing that issue, please feel free to reach out. We're happy to send you what we've done and the transcript from Judge Ellis. And so RESPA, that is a great way to build leverages by using the notice of error and asking for information that they're not going to provide you. What I did in a case, I had a gentleman was referred to me, I think from a legal aid organization. He had a $17,000 mortgage that had come to term, and he couldn't pay $17,000 in a balloon. And so he wanted them to try to work with them. And so he had indicated that, this representative told him one thing and then someone told him something different. And so we did a qualified written request for him, identifying some errors and asking for information. And they didn't provide us the servicing notes. And so, but they otherwise addressed our concerns. And so we sued for violating RESPA because they wouldn't provide the servicing notes. And our guy was just poor. He had no money. His home was probably worth like 75 grand, but he only owed 17 grand. And there was no way that he could come up with the money needed because he was suffering from black lung and his wife also had medical issues. And so I told the mortgage servicer, just give him his house and we'll be done, And they were adamant that they're only entitled to have to pay like $2,000 in damages. And I said, well, I'm just going to keep litigating until my fees equal the remaining 15,000. And then you're going to have to pay, give him his house because they have to pay your fees. And so that's what we did. And he ended up negotiating a settlement, which is confidential, but he now is in his home and he does not have a mortgage, but we just used their not providing servicing notes to leverage an outcome for a guy who was in a bind. And so, Andrew and I were also bringing some of these claims on a class basis, some of these escrow issues. We have disabled veterans who, by the Constitution of Virginia, they are exempt from paying taxes, and they keep having their escrow account, saying that they owe real estate taxes, and it messes up their payments. They're getting charged late fees when they shouldn't. It's a big problem. And so we have FOIA'd, the 90 some counties in Virginia for the list of everyone who's exempt so we can identify our class. And, we've learned that they use a third party service to get all this tax information. Most mortgage servicers use a third party service. And that's kind of how these errors occur, but it's a real problem for the elderly, the disabled, the veterans, surviving spouses of first responders, because mortgage servicers are incompetent. And so we just need to find ways to leverage their incompetence to benefit our clients when they're in a bind. And so anytime you have a mortgage servicing issue, we are happy to help. The most important thing is to get qualified written requests out. They will always not respond. I can send you some templates depending on the issues that your client has, but it is a great way to leverage some value for your clients against mortgage servicers who tend to be difficult to resolve things with informally. Andrew is going to next talk about RICO, how to use RICO to help your clients. So I only use RICO when Andrew is involved because it can be very complicated and can get a little dicey, but Andrew will explain ways that you can use it or consider using it as a legal aid lawyer.
So just to back up 1 second on that too, I'm sure a lot of you see contracts or internet loans that charge rates that are exorbitant compared to what is lawful in Virginia. So as a general rule, Virginia limits the interest that can be charged on a loan to 12%. Outsiders, mostly operating online, try to charge consumers. We've seen rates as high as over 1,000%. Generally speaking, we see a lot of consumers come into our firm with rates somewhere between 200 and 400. Some outfits use 400 to 800. But Virginia's general usury law obviously only covers a Virginia claim. In 1970, Congress passed the Racketeer and Corrupt Organizations Act, which is generally thought of as one of like these boogeyman statutes that applies really to like criminal conduct and organized crime that's not often used in situations where consumers get unlawful debt. But if you look at the statute, there's really three predicate acts. Mail and wire fraud are where you'll find most of the cases, especially on the criminal level. A lot of the cases, if you look at them, are criminal law cases because the statute is not often used in civil litigation. But there is another predicate act that prohibits the collection of unlawful debt. RICO defines that as debt that is unenforceable under state or federal law, that is twice the amount of the usurious limit by state. So if it's over 24% in Virginia, it technically constitutes unlawful debt. Now, there's other elements I'm going to talk about that you need to have in those cases and be comfortable with. But the first thing you want to know is this debt over 24%? So it almost universally is if you're talking about an internet loan. That's why they do it. And so, one of the key things we try to do during our intake is always get a copy of the loan agreement, whether our client logs on and gets it, has a copy. That's just an important first step, so you can see the rate that was charged. There is no federal usury statute, and the National Bank Act preempts state usury laws related to banks. And so if you're talking about a bank that's lawfully operating in another jurisdiction that makes an online loan, I'm not talking about that right now, unless you feel like there's a rent to bank arrangement. For people who don't know what that term means, internet lenders have a large history of non-compliance with state and federal laws. And one of the mechanisms that they tried to do to avoid state law is use a bank as a conduit for their loan, under the theory that the National Bank Act would then preempt state usury laws and allow them to lend at whatever rate they want to. That led to litigation, and both at a government enforcement level and private litigation. It was largely stomped out for a long time, although they recently have brought that back, in part because the tribal lending model of trying to make these loans is coming under fire, both through private litigation and civil enforcement. So, like I said, RICO applies if the debt is more than twice the usurious limit in the state. But that alone is not enough under RICO. It's not derivative of the state law, in the sense that once you violate the state law, you violate RICO. There's more requirements. So some of the other important elements is that it requires an enterprise. And what that really means in a broad sense is that the statute is really targeted at groups of individuals operating together. It's congressional recognition that more harm and danger can be caused by individuals who are operating an enterprise together, as opposed to just individual misconduct. And so there's two different theories of an enterprise, or two different ways in which an entity or people can constitute an enterprise. The first way is really simple, and a legal entity can be an enterprise. So a law firm, a business, a LLC, company. The problem with doing that some people have had, is that the person who violates the statute needs to be distinct from the enterprise. There's a ton of case law on this, that the person who violates the statute cannot be both the enterprise and the culpable person. So to give you an example, Christy and I sued a company called Think Finance. And in that case, we could have pled Think Finance as the enterprise because it is a legal entity. But the second definition under the statute that you could use is a group of individuals associated, in fact, together for a common purpose. If anyone's really interested in this, or is thinking about filing a case in this manner, I would highly recommend reading the Supreme Court's opinion in Cedric Kushner. It's a good read, but it really breaks down the two different ways something can constitute an enterprise, and not run into the distinction problem. And it's interesting too, because it was against, the case involves Don King, the boxing promoter. So it has good, interesting facts. But the association, in fact, is just a group of people who are operating for a common purpose. They have sufficient structural relationships, so they're not this. There requires some type of tying them together with knowledge of what's going on, and then longevity, because you can't operate an enterprise for just one act. Like, the very essence of an enterprise carries some type of longevity, which isn't much. I mean, it's like, as long as they're doing it over the course of several months, that has been sufficient. As far as the purpose element of the claim, it's if you're looking to make money, courts have found that to be sufficient. And so what we've done in a lot of these cases where the lender is really operating more as like a shell front, and there's all of these other players, we've taken a long time to investigate certain companies and outfits who have been making loans to our clients. We have found the individuals that were involved, the investors that were involved, consulting companies that have been involved. To give you one example, in our Gibbs litigation with Think Finance, we sued Think Finance, we sued its CEO, we sued their investors, their shareholders, which was a closely held shareholders, individuals who knowingly gave them money to make the loans, all under the theory that they were acting in concert together to violate usury laws, which is one of the express purposes of RICO, was to stop loan sharking and stop usurious loans. We've been very successful in the Gibbs litigation. I think if you Westlawed it, there's probably somewhere between 7 or 9 opinions in that case alone, that really break down the various different things you'll see in these cases. And so the reason why we find RICO beneficial, there's several different reasons, but it allows you to get and target the recipients and all of the individuals involved in one of these schemes, as opposed to just the lender. A lot of state law statutes, including the general usury statute in Virginia, target the person who collects or receives the money under the usury statute. And so by having RICO, the statute creates joint and several liability for everyone who's involved. So you don't get into these apportionment or offset. Anyone who is a member of the enterprise from the moment they enter until the moment they withdraw, which is very hard to do, can be liable under the statute for the full set of damages. So it's a really powerful statute just on damages, actual damages alone, which would include definitively all of the serious interest paid by your client. What I would also argue is it would also include principal in those states like Virginia who make the principal void because of the definitional language in the statute. It also helps.
One thing I want to just jump in here, Andrew. So a lot of these lenders, because of litigation, have left Virginia, and now you'll see this new thing called the rent-a-bake lenders kind of coming back. And so that's something if you're looking at high cost, small dollar lending, in order to evade this lovely new statute that was passed in Virginia, these individuals, while they're still doing using the Native American tribe, as Andrew's discussed, but you're going to also see now that they're affiliating with some rando bank to try to evade our new laws. And so that's something, if you see and you want to try to do something, we're looking into some of these issues as well. And so that's something to be on the lookout for, because they're always adapting. Sorry, Andrew, go ahead.
No, that's a great point. And one of the other things you'll see in this is a lot of times the contract will have arbitration. And so you'll be prohibited from going into state or federal court. So sometimes the arbitration provision is arguably unenforceable for a variety of different reasons. But if challenged, even in a basic letter from an attorney, a lot of times these outfits will just fold. Part of their business model is to not get involved in litigation. And so if you have a client that comes into your office that, let's say, took out a loan, but didn't repay, took out $1,000 loan, but only paid $500 on it, that person has a claim for damages, but they very may well not want to get roped up in litigation. It might not make sense to arbitrate under those specific facts. But what you would want to do, in my opinion, is to send a letter to the lender to have the debt canceled, or threaten suit. I mean, Christie's got so many of these debts canceled, it's unbelievable. Just by a simple letter, maybe some prying and prodding after that. But they really don't want trouble in the sense of legal trouble of a lawsuit. They have in their procedures just a built-in system in which, as soon as they get a letter from a lawyer or someone that challenges the legality of the loans, they'll cancel it. So that's a really good way to get someone peace, because what happens in a lot of these cases, and we'll talk a little bit about the FDCPA if we have time, but these lenders who are bottom feeders send the debt to someone even worse than them, who harass people, who call their families, who call their work, who threaten criminal proceedings on them, who do all sorts of awful things to these people who were so desperate to take out a loan, and oftentimes unsophisticated and completely scared. And so even after some of our class settlements that canceled these debts, we get calls from class members that say, oh, hey, someone else called me on this debt that's already been canceled. What's going on? They're threatening me with criminal problems. So, if you have someone who has a loan, I think even if nothing else, depending on what the client wants to do, how they want to deal with it, always try to get that loan canceled if you can, if you can do it, because the side effects from not doing that and the impact can be great. It can end up on a consumer's credit report. And like I said, they can be subject to, really aggressive debt collection tactics.
And just so you guys know, if you ever have that situation, we're happy to send like form demand letters, or if you want to talk about which, lender it is, we're happy to, I probably know the lawyer who represents them, and we can just send an email to get the debt canceled, because it is so prevalent. And we've already kind of fought the fight. So a lot of times we have contacts at these places. So we'd be happy to assist your clients, because they shouldn't be paying these high interest loans when they need money to feed their families and stuff. I know we're supposed to leave 15 minutes for questions. And so, Andrew, I'm just going to quickly touch on FDCPA and EFTA issues, and then this couple new changes on state laws that I think people should be aware of. with the, and one thing I do want to say on RESPA is Regulation X incorporated some regulations, some federal regulations, and not all of those regulations have a private right of action. And so there's a chart that NCLC published that's really, really helpful when we're working up cases that says what statutes have private right of actions and which don't. And so if you guys want, you just shoot me an email and I'm happy to send you over the chart. It's our little cheat sheet we use. In terms of the Fair Debt Collection Practices Act, I'm sure everyone is very familiar with that, but it is a great statute because it has strict liability. And so if the statute is violated, pretty much it's an automatic win for your client. And so one thing that we're seeing a lot is these really old second mortgages are coming back from the dead when your clients are finally out of the woods, and they're being threatened with very large debts for second mortgages in terms of judgments, et cetera. And so we've been using the FDCPA to, assert false statements or other issues with the debt collection practice, because what these debt buyers are doing of these second mortgages is they are re-accelerating the debt. So they're within the statute of limitations, but that's not a thing. You can't do that. You can't just send a new acceleration notice because you don't know if it was already accelerated. Can't do that. That's a false statement, and that's an abusive debt collection practice. And we defended someone in a circuit court for $67,000 debt and ended up counterclaiming for some debt collection violations. And we got their case kicked out and then proceeded to get a judgment for our client and get paid 70 grand in attorney's fees because of their debt collection practices. So that's something to be on the lookout. The other thing under the FDCPA is debt buyers are still using that certification of business record statute, 8.01, 390.3, to certify the authenticity of not their business records. And so I'm pretty sure that's also a false statement in connection with the collection of a debt. And so I'm really kind of getting frustrated with this, and I'm thinking about bringing more affirmative claims against these debt buyers when they're making false statements about their ability to certify records that aren't theirs. Like, I just don't think that's appropriate. I think it's a big problem. So you should be on the lookout for that. The Electronic Funds Transfer Act, one thing we see a lot of is people want to stop payment on high interest loans or revoke authorization, because as part of taking out these loans, you allow people to automatically deduct money from your bank account. And so when a consumer would rather pay their car loan or something, they want to revoke the authorization they previously provided. And they're entitled to do that under the Electronic Funds Transfer Act by sending a letter to their lending institution, their bank, and also the lender, as long as it's 3 days prior to the next withdrawal. And then the bank is supposed to prevent the money from being deducted. But what is happening is, one, these lenders are still trying to take the money. And two, banks are saying you have to do a stop payment or close your account. And that's not true. They're saying that because they don't want to follow the law. And two, they get paid when you do a stop payment. So they're trying to make money. And so we've been bringing claims for consumers for violating the Electronic Funds Transfer Act by not allowing a consumer to revoke authorization because they're required to do so under the EFTA. And so that's something, to be on the lookout for. A couple real quick updates under state law. The foreclosure statute has been amended to provide some additional protections for consumers. So instead of the 14-day notice, it's now a 60-day notice. There's also some certifications that have to be made if it's owner occupied. And affidavits need to be provided if it's owner occupied, that certain notices were provided to the consumer. So there are definitely more protections for consumers in the foreclosure process and a bit more time than there used to be. Debt settlement companies also now need to be licensed, and they can't charge upfront fees until they provide the services that are agreed upon. And so that's a really good benefit for consumers, although I don't think it's had much impact because I still see people using debt settlement companies across the country that don't follow these rules. So maybe it's an area where it's ripe to be tested and see if you can have an impact for your client. The other new statute is the student loan statute that prevents certain abusive practices and also requires the student loan servicers to report both, if they're reporting negative, they also need to report the positive. And so that's a really strong benefit as well. I know there's some questions that Andrew and I want to answer, but I don't know, Andrew, if you want to add anything else.
Just one thing, when I said also helping the consumer get the loan canceled, one of the first things that should be done that goes hand in hand with that is a revoke authorization with the bank, just so that it stops. Like Christy said, even when you send the letter, oftentimes it won't, but part of the lifeblood of internet lending really is the ACH, because a lot of times the outfits aren't able to process checks or get a hold of consumers to get other methods of payment. And even when they're told to cancel or do other things, they will give the ACH to a debt collector, and the consumer can all of a sudden get their bank account debit without their permission. So really important in that context to get that done.
So there's a couple questions. I'm just looking through them. The first one that was in here is about navigating a clerk's office that using improper standards. For example, requiring excess bond or not accepting a filing. One thing I do with clerk's offices, particularly in state court, when a bond is necessary, usually it happens in landlord-tenant cases or mortgage cases. And if you're going to general district court and you need to file an appeal bond, that's I always ask the general district court judge to set the bond, and so that it's clear to the clerk and everyone what the bond needs to be. You would just simply raise it if you don't prevail, or the same could be in a warrant in debt or any other capacity. If you think you're going to appeal, you definitely should raise it with the judge, because then it could be part of the order. And so there wouldn't be a way for the clerk to say that some different type of bond would be required. And so that would be my response regarding the bond question. And Andrew, I'll give you this question. In cases where algorithms are involved, what kind of defenses are companies using, and how do you get around them?
It's a good question. So in cases where they're involved, you know, I'm generally talking about from a credit reporting sense. So what you'll see is, like, first of all, it will be very difficult for you to get them. They will fight you. And so if you want briefing on that and how to get it and why it's important, that's something you can talk with us. But the algorithm of the way a consumer reporting agency matches information, it varies from each consumer reporting agency. Experian, Equifax, and TransUnion have a far more robust process upon which they match information, generally speaking. from someone like RealPage or these tenant screening companies. And so in our cases, and I think one of what goes to the heart is that oftentimes the consumer reporting agency, their customer, their clients, they're not consumers. They sell information to banks. Banks pay them money. Tenant screening reporting companies get money from property managers. The goal of the industry, in a lot of senses, often is to be over inclusive. They would rather get information on a consumer that is inaccurate and not rent to them because they have other people they can rent this apartment to. And so if there is any potential red flag out there that's just associated with this consumer's name, they want to know about it. And so, when we fought in various different cases for this information, oftentimes it will come with studies that show they know how bad this is. And so you're really talking about what the process is by which a consumer reporting agency matches information to a consumer. And unfortunately or fortunately, we haven't gone to a jury on this particular issue. Others have, but I don't think anyone would feel sorry for these people when they realize how intentional the loose matching is. And so you want to, if you're doing a case like this, you just need to really go after that type of information, both what it is, how much they know about it. And then I think anybody should be very comfortable explaining to a jury why Terry Brown shouldn't be matched with Terry Brown because they have the same name. Christy, you have anything to add to that?
Well, yeah, I mean, I think it kind of goes back to what we said at the beginning about discovery, right? You got to get the algorithm. So you got to be diligent so that you can show it's unreasonable. And like Andrew said, they're going to fight you for that because it's never going to be reasonable because they're not trying to follow the law. They're trying to make their customers happy. And so that's why, going back to the importance of discovery. The next question we have is about the eviction expungement. And it's just kind of wanting to flag for everyone that, there's been a lot of talk about like the criminal expungement bills or criminal sealing bills, and also the eviction expungement bill. And we should really be planning how to help our clients. And I know that Deep D at LS&V and Jay at BPLC have talked a lot about trying to create an initiative to provide awareness and help people with expungements so that we can get these on file when it becomes effective in January. And so I would definitely be happy to help with any of these processes. I know that people more capable and smarter than Andrew and I are already working on this, but if there's anything we can do to facilitate this, or if you have questions about it, I would definitely talk to either Jay or DT. I know in terms of the criminal record issues, they're still working through those. That has a more delayed enactment. And there's a lot of other issues. I'm on the Crime Commission study that's talking about barrier crimes. And so there's a lot of other things still being worked through in terms of the criminal sealing and expungement stuff. But the eviction stuff is going to be enacted and effective January 1. So it's definitely something that everyone should be aware of so that we can help our clients. The next question is there a limit on the amount of interest that can be charged for an auto loan in Virginia? And that is a tough one because that is a closed contract generally. It's not an open-end line of credit, and it is not generally a small dollar loan governed by Virginia's usury statute. And so that there's usually not much you can do once your client's in a high interest auto loan. Unless there's issues about the way the loan was entered into. There's other issues of fraud or inducement. There's issues with disclosures. Although the law in Virginia with used cars is so bad right now, they can just bury one notice in there and say, this car sucks, it has everything wrong with it, and you agree, like, our car sucks, and you still are stuck with it, even though you discover all these defects. So I hate car dealers, and I hate that they have an amazing lobby, that they continue to erode protections that consumers have. But I don't know, Andrew, if you have anything you want to say about that.
Just that most of those contracts are probably also by national banks or someone else who would qualify for, in addition to not being a small dollar loan, they're probably exempt in most places. But I'm not overly familiar with those exemptions, and so you just have to run through. I assume in the 6.2-303, there's a series of exemptions, and I assume that the auto would fall in some of those.
We have a question for some RESPA qualified written request templates. I'm happy to send them. If you just want to email me or Andrew, we can send you some templates for RESPA, or if there's a good place to post them, I'm happy to do that as well. Comment about the EFTA. Is it the most violated statute in the US? Probably, because every bank violates it so that they can make money. And if you ever have a client who you had this happen to, please reach out to us. Like, this is like on my list for, you know, cases I want to litigate. And so I'd be happy to help you share pleadings that we have done in the past. But yes, I definitely agree. The next question is about, there's a question about the criminal records algorithm misclassifying criminal records, and it can affect whether the look back periods may differ. Does 1681G entitle a consumer to a disclosure of how a crime was classified? So Andrew, can you talk about what 1681G requires, and if you want to talk about misclassification briefly?
So 1681G requires a consumer reporting agency to furnish all of the information in their file to the consumer. And so in my view, if a infraction has been misclassified and the consumer asks for a copy of their file, it should appear as is in their file, and it should be pretty clear that it was misclassified. What you will see in a lot of times is that consumer reporting agencies claim to not keep records of what they furnish to third parties. Even the big three don't do this. And I actually, if I could do one thing to the Fair Credit Reporting Act, if it was up to me, I would make a statutory section that required consumer reporting agencies for 2 years to keep a copy of the report that they furnish. Because we deal with this all the time in cases. Oh, I don't know what I sent to them. I just know what was in the file. And so sometimes you'll see it because it should appear the very same way in the file as it is given out. But you know, it's not. It's certainly one of the ways in which consumer reporting agencies try to avoid liability. But to answer the question, under the statute, everything should be disclosed. I mean, it says all information, all. So nothing should be withheld under the statute whatsoever. It needs to be clearly and accurately disclosed. And so that certainly should be in there.
And I think if you do request the consumer disclosure, you will see that it was misclassified if in fact it was, because they're not thinking, oh, we better make sure it's right before we send this to a consumer. They're just giving you what they have. And generally their ability to pick up and accurately report criminal record information is terrible. I mean, we see this all the time. And so I would definitely, if you have a client who has an issue with something that appeared in a tenant screening, employment background check, or whatever the case may be, reseller report, ask for the file and you will see that information. And I mean, 9 times out of 10, I'm sure it's going to be improperly classified. I have a client who applied for a tenant screening report and he was in DC a long time ago, and he had an assault charge and he was arrested, but the U.S. attorney or the attorney, Commonwealth attorney, the District of Columbia attorney, whatever, didn't decided not to press charges. And in DC, they just call it no papering. And so he has this arrest that was no papered, and it's from 2003, and it's still reporting in his tenant screening reports as a criminal record when it shouldn't be, because he was never convicted of a crime. He wasn't even charged, and they just declined to even charge him. And so, there's a lot of problems because different jurisdictions maintain records differently. And so it's always good to get the report and request the disclosure so you understand what was reporting about the consumer, what remains in the file. The next question is about the affirmative actions against third-party debt buyers presenting affidavits, certifying records of different organizations. Would you bring this out as a counterclaim in general district court or file it affirmatively in federal court? And I think, from my perspective, because I'm actually considering doing this now and I've been battling this question around in my head, is do I just want to counterclaim in GDC, or do we want to just bring an affirmative case in federal court? I'm not sure what we're going to do, but I'm thinking we might bring a case in federal court because we're more comfortable there. But whatever you do, I think you need to do it before there's a final adjudication in your court case, right? Because you don't want to be stuck with, oh, you should have raised it in this case. And, where the court considered the affidavit and found that, it was, proper affidavit or whatever they would do in your client's trial. And so whatever you need to do, you would need to do it, I think, before the final adjudication in your general district court case, because you don't want to be in a position where you have like the Rooker-Feldman doctrine or anything else coming into play that could prevent you from asserting your client's potential claims. The next question, Andrew, is any thoughts on how to plead to avoid standing issues in a statutory damages respite case? And maybe, Andrew, you can briefly talk about Ramirez and why everyone should be aware of Ramirez who are bringing affirmative cases.
So in Ramirez, which I'm sure most of you are familiar with, recent Supreme Court case about statutory damages in an FCRA context. Ramirez found that certain consumers did not have standing and did not have an injury because it was either there was really no publication of the report, TransUnion didn't furnish it to anyone, and therefore no harm covered by the statute to give the consumer standing. Most of us generally disagree with the decision. And so one of the new frontiers is how to deal with the post-Ramirez world. The easiest answer to that is to ensure that your client, you're doing everything you can to build up your client's actual damages, to make sure you have all of the conversations, you make sure you know exactly what's happening. And so there is concern moving forward in RESPA. I think Christy would share this concern that a request for information under the statute, if you're just requesting it to request it, and they don't comply, you're going to probably have some Ramirez problems. But if you can explain why your client was harmed in that particular instance by the refusal to give certain information, I think you'll be fine in the post Ramirez world, especially if it's not a class case. What didn't help the cause, I think, in Ramirez was that TransUnion was looking at like a $60 million judgment. And so that doesn't sit well with certain people. And so I think the court was looking for a way of getting TransUnion maybe out of that bind. But as long as you request information and you want to, like, for example, in a lot of our recent cases, we're requesting information because they're saying our client is late on a payment, and we think that information would be within the files. And so tether your request to a real world harm that is being suffered by your client, and I think you'll be okay. But if you're just requesting information because, hey, I want to request this, and if you violate it, I'll have a claim against you, that's obviously not going to sit well.
I mean, and in the mortgage context, you can really say, I talked to so-and-so on this date and she told me this, like, please send the servicing notes, please send the recordings so you can verify. And I have from my records this information if you refuse to correct this error, right? So you're trying to tie it to your grievance. And it's not that hard in the mortgage servicing context to do that if you have a client who's really has some issues, or if they haven't had any communications with their mortgage servicer, they certainly should, because that's, the best way to have them make false statements to your client. And, I mean, no mortgage servicer is perfect. If your client is being diligent and trying to get a resolution. So I think we've answered all the questions, and we're here if you ever need anything, or if you have any questions, or you're going to do any of these cases and you want templates, or you want to talk through them. Please consider us a resource. We really value everything that you guys do as legal aid lawyers, and we're committing to help you, in any way we can. So thank you for all you do, and feel free to reach out to us anytime. And
yeah, just to add to that, there is nothing more near and dear to Christy's professional heart than legal aid, and therefore nothing more near and dear to my heart as her partner. So anything we can do, Christy, she will take any call, help you out. We'll help you out. Just let us know.
All right, thanks you two. That will conclude this session, and we look forward to seeing you all in future sessions during the duration of this conference. Thank you.
Thank you.